Welcome back to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal, and in this particular YouTube video, we will be looking to provide direction with respect to the question, can I sue my employer if I left my job? So, as opposed to being fired outright from your job, you decide to leave, resign, and depart your position with your employer. So the answer to that is maybe. And why do I say maybe? Well, it all depends upon the facts and circumstances of your employment situation prior to your leaving, as well as the prevailing case law in your jurisdiction, whether that is federal, provincial, state, city, local law that is determinative. Both the statutes, the regulations, various codes, and the case law or the law as made by the court in previous cases of a similar nature that expound upon your position. So what are those circumstances and what is that legal area that you're looking at? Well, most likely what you're looking at is the area of constructive dismissal, or in part, workplace harassment that has predicated your decision to say, look, I cannot work in this environment anymore, whether it is because of harassment or because of actions undertaken by my employer to effectively alter my employment with this company that was done unilaterally and against my will, and has had a serious and negative repercussion on my employment, such that I took it upon myself to say, enough is enough. I cannot persist in this arrangement where my position is being poorly treated and I need to leave. Now, the first thing you might look at is if you have an employment contract, because employment contract will give you some guidance as to what the obligations of the employer is. Nevertheless, given the fact that almost all employment contracts are drafted in favor of the employer and by the employer, they are not going to provide as great a disposition as one might anticipate. They could very well have issues with respect to technicalities in their drafting. Nevertheless, given the preponderance of control that was in the negotiating of the arrangement, such that the employer typically has a very one-sided contract, it will become necessary to look to other aspects that go outside the contract and that also serve to put the contract away in a technical sense. And what was one looking at then? Well, one is looking at a situation where the employer has created an environment or taken upon itself actions that has substantially altered the employment arrangement as had been agreed to, as had been contemplated, and as had persisted between the parties prior to the employee making the decision that they can no longer work in this work environment. So what has possibly happened? Well, if one looks at constructive dismissal, there are a variety of circumstances that might have happened that precipitate this. For example, there may have been a unilateral change in the powers or duties of the employee. Now, this might be an overt change that is done exclusively by the employer, or it might be through the tacit admission of the employee, but only because the employee knows that they could not otherwise continue working. But when they take on this situation, they realize that their demotion is far greater than they anticipated. They wanted to keep their job, but then they realized that the demotion that the employer is putting on them is not acceptable. Hence, whenever this first comes to bear, when there is a suggestion of a change, that is a point in time where the employee should be immediately engaging legal counsel to get some proper advice as to what they should do and what they should be preparing themselves for. Because what is in effect happening is they are being forced out, or they're being threatened to force out. Another aspect could be where there is a unilateral change in salary, in the number of hours that are being worked, in the status of the employee, in the amount of benefits they're receiving. Certain aspects like this that go to the essence of the employment arrangement and are unilaterally pushed down on the employee are of consequence and can constitute a constructive dismissal, giving rise to a rationale for suing one's employer, or in this case, former employer. Also, a change in the working relationship, where the employer was trying to effectuate a change, try to push out the employee by issuing threats, issuing threatening suspensions, effectively suspending, changing the work reports in an unfavorable manner that had not preceded, and where the work level and the quality of the work wasn't necessarily changed in any respect. So these threats, these suspensions, these negative notes on the employee record may simply be the product of an employer attempting to get ahead of the process and to have a justification for their actions. So they start creating this false narrative, as one might say, or hyped up narrative, where these actions were being never reported and never existing previously. And now there's this creation of this new sense of this employee is not really the kind of employee we want to have. So they have this kind of presentation that will justify them potentially in forcing the employee to quit, to resign, and then giving the employer justifications for not paying them more than what they were deserved. And this in turn leads to our second aspect where one might find themselves, and that is in the creation of a hostile work environment. So the negativity that comes in those circumstances might represent transgressions more than to the employment arrangement, but actually to the human rights of the individual who is being threatened and who is being subjected to this hostility, to this callous or unwanted environment. Naturally, with all this stuff, one needs to look at the underlying law and what's permissible upon which to sue and to act upon it. And where possible, it's advantageous to collect one's evidence, notes, information, potential contacts. People can establish that this was, in fact, the situation that one was feeling, such that they find themselves having to leave. So oftentimes it's a matter of taking this down, staying a bit more time so you get a full record of it as to why then one needs to leave this particular position and still have the right to sue their former employer, given the fact that the egregious actions of the employer should not be relieved simply because the individual has had enough of the situation and has taken steps to depart. So whether one quits or when one resigns or otherwise leaves their employment, that does not leave the employer scot-free. Dependent upon the facts and circumstances and how those tend to be interpreted in one's particular jurisdiction, based on statute, rules, guidances, and case law, there may well be the basis for initiating illegal action against one's former employer, even though one left the job, and that was out of abundance of caution for their personal safety and well-being, and because there is technically no rationale that should force one to continue to work for an employer who has perpetrated these actions, where those actions suffice to make a proper claim to the court subsequently, or to otherwise simply need to depart. But it's something that needs to be properly analyzed by knowledgeable legal counsel, looking at all the facts and circumstances that abound and what the implications are of pursuing this in the courts and potentially negotiating it in advance of it going to trial. I trust you found this YouTube video informative, and will speak to you further on matters of law. Thank you.